Hello friends, in the series on the income tax cases, today we will discuss the case of ANOOP GOPIKISHAN JAJU versus Assistant Commissioner of Income Tax. This case has been reported in 105 ITAT Tribunal Short Notes 22 and the matter has been decided by Pune ITAT A bench. The date of the judgment is 23rd June 2023 and this case is regarding section 69 addition which talks about unexplained investments. It is very common in the case of the property transactions that some money is received in cash and correspondingly it is paid in cash by the purchaser also. But nowadays when there are transactions of purchasing flats, although these transactions have reduced considerably due to increase in the circle rates also, and in some cases even this is the situation that the market value of the property is less and the circle rate is high. But this is not the issue in this case. In this case, there was a survey on a person MPD, and in that survey MPD admitted in its statement that it has received money over and above the check transactions for the sale of the properties to the various purchasers. And in that survey, corresponding ledger with the details, name, address, area of the property sold and some other details were also found. The person on whom, that is MPD, on which the survey was made, surrendered an income of near about 8 crore rupees and then also increased it by 2 crore. And the person on whom the survey was made went into the settlement commission and the order was passed admitting the income of the person on whom the survey was made. When this whole exercise was completed, on the basis of the information of the various purchases, their cases were reopened, and the persons whose cases were reopened, Mr. ANOOP GOPIKISHAN JAJU was one of the person on whom the addition under section 69 was made in respect of payment made by him in cash to the MPD. It was the case of the department that it is not only the statement on the basis of which the addition has been made, but that statement is corroborated by the ledger found and the other details found in the survey of MPD. For example, name, address, details of the properties and the dates on which the cash was received. And that addition was confirmed by the CIT appeal also and by the ITAT also in this case. Friends, although in this case, the case of the assessee is weak because various documents have been found relating to the assessee at the premises of MPD on whom the survey was made. But with due respect to the Pune ITAT, if the assessee opts for cross-examination of the person during the assessment proceedings or at the stage of the first appellate authority, that an opportunity of cross-examination should be given to him before making the addition under section 69. So my point is that without giving this opportunity to the assessee, the addition should not have been made, because nowadays it is not a difficult task that I may know the other person's name, address, the property details and write in some ledgers, and I can offer this income in my survey and can give the tax at 30% because I am explaining the source that it is from the sale of land. So that does not mean that if I am writing the name of some person that person has given me the amount, and simply because of some documents have been found or some statement has been recorded, without giving the opportunity of cross-examination to the assessee of the person on whom the survey has been made or the search has been made or on the basis of whose statement the addition is going to be made, the addition should not be made. This is the basic principle of law for making the addition. But with due respect to the High Court, the facts of the case may have been some more favorable to the department in this case. So the ITAT go ahead with the addition made by the assessing officer and confirmed by the learned CIT appeal. At the end of this video, once again, I am repeating the name of the case. The name of the case is ANOOP GOPIKISHAN JAJU versus Assistant Commissioner of Income Tax, and this case has been reported in 105 ITR Tribunal, short notes 22, and the matter has been decided by Pune ITAT A bench, and the date of the judgment is 23rd June 2023. Thank you, friends.